Hello, everyone. Nice to see you again on this international introductory trailer. Today I'm going to introduce a case or brief a case to you that concerned with the formation of contract and also the freedom from form principles, which we have talked discussed in the uh, in the episode before. So this case is the Clout case 1017, the Belgian pages. It's really interesting and very classic. And through this case, we can learn some important ideas when you are dealing or handling international transactions, commercial transactions. Yeah. Firstly, we go to the case itself. Yeah, it's the PDF file I have derived from the internet. Yeah, this the case number is case 1017 CISG. Yeah, it's it's not it's just only 2 pages. Summarized in 2 pages, but uh, the summary has a lot of uh, important elements. Firstly, we can go through the facts. Then there are three issues concerning with this case. Okay, and the first paragraph of the summary is the fact of the whole case. And I would suggest that every student could, just look into the PDF file, and if you find some key points, just underline. For example, the first sentence, they have two important elements in the fact. Firstly is the Belgian seller and the French buyer, which indicates the buyer and seller are international parties, which will be subject to the CISG. And then second, the transaction object is the pages, production and supply of the pages. So it will be produced by a Belgian company and sold to a French buyer. Yeah. So we can make some note here. When you underline it in a PDF file, you can make some note here like the it's the international transaction that will be would be subject to CISG. Okay, so you can make note here that will help you to summarize your own version, summarize your understanding, and then transformed into a mind map. Yeah, that is the mind map after I reading these 2 pages of summaries. Okay, I summarize the whole case into 4 parts. The first part is the whole fact. The second part is the issue. The first issue is talk about the competence of the court, whether a Belgian court can handle this case, or is the French court who has the competency. And the second issue is the formation of contract, because in this case there was no contract. There was no a formal contract. There is only a LOI, letter of intent. And then the fourth part is the third issue. Yeah, because the pages, yeah, the transaction um, was not so successful because of the disappointing sales of the pages, because it's something already maybe just at the end of its production or at the end of its product life. So nobody want to buy it anymore. So the parties just decide to make some make some solutions to the unpurchased, unshipped pages, so they had came into some amicable resolution. And it's that kind of resolution put in a written minutes could be abiding to both of the parties? That is the third question. And at last, the whole case may bring us two most important ideas. I put here the reminder. Yeah, that's something you should always keep in mind even after this class, and share with your colleagues and your bosses when you are work in an international environment. That is very important. The first reminder or the first idea that this case told us is that always take LOI seriously. Always take letter of intent serious because it will be binding in some extent. And the second idea that I want to share with you is that if you receive anything that you don't feel good, please respond promptly as soon as possible when you receive it. Never postpone it, because in this case, the seller just postponed, doesn't reply when he get something he don't like, and then that put him in a very disadvantaged status. Okay, go to the case. Don't go to the fact. The fact could be put into three uh, subsidiary part. The first, as we have known, is a French buyer versus the Belgian seller, and they have a letter of intent but no formal contract, and the goods to be purchased is 30,000 pages. Yeah, not phone pages, because at that time the pages haven't been replaced by mobile phones, and then they have agreed on 30,000 pages, but the delivery time and unit has been specified by later communications. Yeah. And they agreed the communications and final agreement will be governed by the French law. So at this first point, we have to take care that there will be an issue about the competency, because they have agreed that the case, the transaction will be governed by the French law. Maybe only French court can have the competency to review this case. And then after the signing of a letter of intent, and they just negotiate some details in the letter. But after then they found the sales of the pages, in the consumer market, it doesn't looks good. So they just negotiate with each other whether or not to carry on the remaining pages sales. So and they agreed. They agreed in maybe in oral, and the buyer has drafted a minutes about the amicable resolution on this case. And the buyer sent these minutes to the seller, but seller doesn't respond. They just they just respond after 1 month, and then send them and notice that the seller request for a full amount of 30,000 pages, which doesn't in accordance with the the minutes, the amicable solutions they have agreed before. And so then came to the first issue: which code, the French code or the Belgian code, has the power uh, to adjudicate this case? And the first instance of the Belgian code has rejected, because the main obligation was to perform in the France, because the produce is shipped to the French buyer in an address in France. So the first instance of the Belgian court has rejected they have the right to review this case. And then, but the LOI, the letter of intent referred to the French law and both the CSG. And then the buyer's obligation to pay, yeah, they haven't specified in their communications where to pay the money. And then subject to the CSG, the payment has to be made in the seller's place. That means in Belgium. So the Belgian code, both of the Belgian code and French code has the right, has the power to review the case. And then that came to the issue 2, whether or not they have a contract. And then for a contract to be formed, there should be offer and acceptance. And they have offer and acceptance in conduct because they have gradually negotiation and then lead to an agreement, maybe not in writing, but they can be observed in their communication that they have been agreed in the price, in the objects, in the details. So they can be sure that they have a contract, but not, although that is not in writing. And then the LOI's legal status. Yeah, because the LOI has stipulated some important elements. And for an agreement on principle, it is already sufficient to be deemed as an agreement in principle. And then the LOI is to prevent parties from stepping back. So LOI could be abiding. So be seriously. LOI could be a very binding. And then the parties just kept on negotiating agreement reached on a certain point. Yeah. So after they signing the LOI and they keep on negotiating, keep on communicating on the details of the contract, on the detail of the pages for the payments and for the delivery. So it could be viewed as the contract has been formed between them. And then came to the third issue. The third issue is about the binding of the amicable resolution. Because, as I have mentioned, the pager sales doesn't work out very well in that time. So they just came to they need to reach another solution. Yeah, 30,000 pages doesn't practicable. Yeah, so they just meet with each other and they formed a minutes of amicable resolution. And that amicable resolution shall be considered as a modification and the termination of the original contract. And the seller have received the minutes sent by the buyer, but the seller didn't react within a reasonable time or question the content. So that means they just receive and put in the desk. Yeah, put on the desk and left it. And for a certain maybe over 1 month, maybe they just put it after and review it after holiday. And the parties has yeah, that is an international principle, an international legal principle that if you don't feel good about something you receive, you have to protest within a reasonable time. And it's an international principle. And yeah, that principle comes from the interpretation principle of CSG Article 7 and also a rule of good faith. Yeah, if you don't like it, just respond it, just reply as soon as possible. Yeah, so at last, the buyer and the seller just win and have the part they feels reasonable. Okay, so once again, just remind you that always this case tells us always take LOI seriously and respond promptly when receiving something you don't feel good. Okay, and that is the end of this demonstration of the case. And I hope everybody could take more seriously on this case because it's very classical. Thank you. Bye bye.